Hello everyone, Andrew Bethel with the Bethel Law Corporation, and today we're going to be covering a topic that is pretty fundamental to the world of estate planning. Last wills versus living wills. Just what exactly are they and what is the difference there? Now, I know we've all seen the scene in the movie of the reading of the will. Somebody has passed away and the whole family comes over to their house, and the deceased person, their attorney, comes in with the will and reads it out loud to the family, where everybody now finds out what they get. For a modern example of what that looks like, you can look at the 2019 movie Knives Out. The entire conflict with that movie centers around an attorney reading the will and the outcome not being what everyone expects. Modernly, though, we don't do that at all. It's much less dramatic. When somebody passes away, their original will just gets logged with the court, and written notice is sent out to anyone with an interest. For example, children or somebody named in the will as a beneficiary. Much less dramatic that way, much more dry, boring, and legal, but wills are still very important and fundamental to the world of estate planning. But one question we do get a lot in our office is, what is the difference between a last will and a living will? And even, is there a difference? So before we kind of get into the differences between the two, I do need to cover what is a will just in general, so we all have a basis of understanding. So a will is a written outline or instruction as to who your heirs or who your beneficiaries are of your estate and how much everyone is set to receive. So for example, I can write down that I leave all of my estate to my 2 children. Each one gets 50%, and having that written down is my last will. Now, in that document, there are a couple vocabulary terms you should be aware of. First of all is the testator. That's the person who writes the will. So in this situation, it would be myself. Additionally, you have the beneficiary. A beneficiary is someone who is going to receive something from an estate directed to them by that will. Now, I do have to differentiate that a little bit from an heir, because oftentimes we use the words heir and beneficiary kind of as a substitute for one another in common layperson talk. Now, an heir can be a beneficiary, and a beneficiary can be an heir. But really, when we say those words in the legal field, an heir is referring to someone who might be considered what is called a natural heir. For example, if I have 2 children, as I said before, each one of those children would be my heirs. If they are set to receive something under my will, they would also be beneficiaries. As a counterexample, if I were to leave half of my estate to my son and the other half to, for example, a charity, then my son would be my heir as well as my beneficiary, and that charity is a beneficiary of my estate. Now, what exactly does a will do for you? So aside from what we can kind of gather already, which is distributing your estate to your beneficiaries after you pass away, your will is also going to do a couple other different things. First of which, you're going to nominate an executor of your will. Now, the executor is the manager of your estate. Now, I say nomination because if your estate does have to go through probate, you do need the court's approval and appointment of that person as the executor. As a side note, you might hear administrator or might come across that term when looking at estate planning. The administrator in this situation is also someone appointed by the court, but they've been appointed where there's been no will. So where there is a will and someone is appointed as the manager, they become the executor. Where there is no will and someone has been appointed as the manager, they become the administrator. And finally, one of the other common things that is seen in wills is a nomination of minor guardians. So if I have underage children, so for example, I have a 10-year-old son, I can list in my will who I nominate to be that child's guardian. Again, it's a nomination process, it's not definitive, but having that down in writing will go a long way with the court in granting that person you nominated the authority to take care of that child. So again, what your will can do for you, or what your will does outside of distribute property to your beneficiaries, is also set the manager, that's the person who's going to be managing that distribution, paying off debts, as well as setting the potential guardian for any minor children you might have. Now that we've discussed what a will typically does for you after you've passed away, let's kind of differentiate a last will versus a living will. Might sound a little counterintuitive to have a living will if the whole point is that it is something that goes into effect after you die, but here we'll kind of discuss what is the difference there, because they are actually referring to two different types of documents. So a last will is just a shortening of the last will and testament. Now everything I've discussed up to this point, so a document directing who your beneficiaries are, nominating an executor, and maybe nominating a guardian of your minor children, that is what would be considered your last will and testament. Now a living will is a little more old-fashioned. We don't see them too much nowadays because modernly your living will is something that's now known as an advance healthcare directive. Essentially, your living will is your instructions as to your potential medical care should you become incapacitated. It covers things like whether or not you want a breathing tube, a feeding tube, whether you object to something like a blood transfusion or certain pain medications. Those type of decisions will be handled in your living will, and again, modernly, we now refer to them as advance healthcare directives. The reason they have a different name is because they're now more encompassing and have a lot more in the documentation, and can also be used to extend to your medical care and concerns even while you're not incapacitated. So an advance healthcare directive can also be called a healthcare power of attorney. Now we all might have a general idea of what a power of attorney is, but as a quick intro as to what they are is essentially a document wherein you're designating someone to operate on your behalf on matters of either finance or healthcare, or maybe even something very limited, like a limited power of attorney to be able to sell a piece of property on your behalf. So under an advance healthcare directive, you as the writer are what's known as the principal. The person you're giving authority to act on your behalf is your agent. Now, modernly, good advanced healthcare directives will also have the modern HIPAA language, which allows your agent to be able to also manage not only your medical affairs, but your medical records, the release of your medical records. For example, if maybe you're not incapacitated, but you do find it difficult to be able to contact one doctor and have your medical records, released to another facility, then under an advanced healthcare directive, your agent can then authorize that release so long as you have the modern HIPAA language in there. And additionally, since this is also similar to a general power of attorney, you do have a little more flexibility when it comes to when it goes into effect, and you can even put an expiration date on them. So as I mentioned, one of the big things that we now do, as opposed to an old living will, which goes into effect at your incapacity, is we can set the advanced healthcare directive to go into effect immediately or go into effect upon the happening or occurrence of some event. It's what's called a springing advanced healthcare directive. One of the common requests that we get for a springing provision is where you as the principal has been judged as incapacitated or incompetent in writing by one doctor, or oftentimes people ask for 2 doctor's notes. although most of the time we set the documents to be effective as they are executed because you never know quite what might happen. The whole point of these documents is that they can spring into power right when you need them, but we don't always know when we're going to need them. So we typically set the documents to go into effect right away, unless there is a particular reason we want to hold off. Now again, that is an advanced healthcare directive, which modernly has taken the place of a living will. Now that we've discussed all that, the final question is, do we need both a last will and testament and an advanced healthcare directive? So hopefully through my explanation, it has kind of become clear that the last will and testament and your advanced healthcare directive are actually two very different documents. They operate very differently and even go into effect at very different times. Your last will and testament goes into effect after you've passed away. Your advanced healthcare directive goes into effect either immediately or when an event happens that you set. For instance, one written doctor's note saying that you're incompetent. And your advanced healthcare directive will always expire upon your passing, even if regardless of whether you set an expiration beforehand or not. Your last will and testament only becomes effective at your death and only takes care of your estate at that time. So having both documents as part of your estate plan is essential to having a complete estate plan. Life is full of unexpected events, and the whole point of having documents like this in place is so that you or your family can accurately and efficiently respond to any potential events that happen, especially the surprises. So, in summary, both documents are important for your estate plan and go towards having a complete and all-encompassing estate plan that does cover any and all eventualities. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.